Washington State Supreme Court to let, this is the writing here, activist judges dismiss cases arbitrarily, once again overriding Washington voters' state legislators. I'm going to read for you, this is something from March 31st, way back in 2021, Washington Court. This is a press release. Racial justice, because they've established this group there. Talking about racial justice. Washington Judicial Branch, with a year-long structural change that could help end racism, devaluing of black lives within the state's judiciary system. And they had a meeting on the 26th of March 2021. And they decided, they came up with a response in the open letter. They said that they're going to challenge members to look honestly at racial inequality in the justice system. Quote, we continue to see racialized policing and overrepresentation of black Americans in every stage of the criminal justice system. Our institution remains affected by the vestiges of slavery, Jim Crow laws that were never dismantled, and racism disavowed. The letter goes on to say the legal community must recognize that we have ongoing injustices and we are capable of taking steps to address it if only we have the courage to do so. So one of the things, or a couple of things they've decided to do, and this one just happened, they are now going to let judges, the judges, not the prosecutor, but the judges decide from the bench whether or not they are going to hear a case. And that's unusual and different, but the Washington Supreme Court says the judges can step in because, for some reason, again, because they're trying to get rid of racialization and policing and a whole bunch of other problems that they see. And this is sort of what they started in 2021. So I thought we'd have Scott O'Toole on, a former Senior Deputy Prosecutor there at King County, now moved on, and you're working with the Washington State Criminal Justice Training Center. And last time we had you on to talk about this, your dog had more to say about this than you did, Scott. So we thought you'd give a chance to respond in English, if that's okay.
Thank you, John, and thank you for your patience. My dog has gone off to law school, so I'm by myself.
All right. So let's talk about this particular one and why this is such a head-scratcher and possibly shocking the conscience of the court. Walk us through how it normally used to work before the Washington Supreme Court comes in and says we're going to let judges sort of decide whether or not the cases can be heard. How did it work in Washington prior to what the judges have come up with?
Well, this new rule is called Criminal Rule 8.3. And what this allows is a judge to dismiss a case in the interest of justice for, say, governmental misconduct. And that means it could be extreme misconduct on the part of law enforcement or on the part of the prosecutor's office. For example, if the prosecutor was to not disclose exculpatory information, that type of thing, to the defendant, depriving the defendant of a fair trial, that could be a basis for dismissal. But in the past, and the precedent for decades, going back at least 40 years, is that dismissal under Criminal Rule 8.3 is what's called an extraordinary remedy. And you only grant it where there's been actual prejudice or some actual negative effect on a defendant's right to a fair trial. Short of that, there's really no basis historically to have granted a dismissal. What the new rule now allows is a very, very discretionary, arbitrary standard for trial judges. In fact, there's no standard at all to limit the judge's discretion. It renders a Criminal Rule 8.3 dismissal totally subjective. So in fact, for example, the case provides a number of factors that the judge should consider, including the seriousness and circumstances of the offense. Well, that's fair, right? In addition, the impact of a dismissal on the safety or welfare of the community. With a parenthetical, the defendant is part of the community. So are we now judging the impact on the safety or welfare of the community generally, or on the defendant individually, and should that have any bearing on whether or not we should bring charges against him? Then the impact of dismissal or lack of dismissal on confidence in the system, et cetera, et cetera. But the real catch-all, the real provision for concern is this. In addition, the court may consider any other information that the trial court believes is relevant to an inquiry. So what exactly does that mean? Because in our system, we have a separation of powers, as you know, judicial, executive, and legislative branches. The executive power is vested in, amongst others, the law enforcement and prosecutors. We enforce the laws. The legislature passes laws. The executive enforces the law, and the judicial branch interprets the laws. And there's never been any disparity about that. So who files charges? The prosecutor's office. We have the discretion to file charges, to not file charges, to file less than the charge that's requested by the police or a more serious charge. But that's an executive function. So what happens if now you get a case in front of a Superior Court judge and the defense attorney says, you know, Your Honor, I think in your discretion you should dismiss this just in the interest of justice. And what you need to know is, I think that the charging of a particular group of defendants, whether by race or ethnicity or sexual orientation, is overrepresented in these cases. That shows inherent bias and prejudice against that group. That's in the interest of justice, and that would give you the basis, because if you find it's relevant, this case should be dismissed or not brought at all. And that violates separation of powers. It completely overrules the case law that's been in existence for at least 40 years. And it does it not by actually overruling a case, but by imposing a brand new rule that the court has imposed on the criminal justice system that completely invalidates what had come before. You don't have to reason why this is a good idea, because there's no case law that actually supports this. It's just a brand new rule that we've now invented.
So the Washington Supreme Court, so going back to 2021, their antenna were up, and they were going to do everything they could, referring to Jim Crow laws that were never dismantled and the racist disavow. They became sort of hypersensitive to this, and then they have come up with a series of rulings. Prior to this one, there was the case of the woman that was in the fender bender, and then the defense, or the prosecutor defense attorney, who was describing the woman as irascible or hard to interview, or angry or something like that. Then I think her defense attorney, when she didn't get what she wanted in the fender bender, I think she got $60,000 instead of $1 million or whatever it was. They then said, well, that the other side used sort of racially tinged words, biased words, to describe my defendant, my client, and therefore those words prejudice the jury. And then the Washington Supreme Court said, yeah, you know what, you're kind of right in this case. If you use certain words to describe certain people, well, then the case could be thrown out. And I think it was Judge Alito saw this, and he was shocked and even wrote something about it. Walk us through the actions of the Washington Supreme Court when it comes to words describing individuals and then also injecting bias into the jury's mind.
So the case is Thompson versus Henderson. I think it's from 2022, if I remember correctly. And it's a case, as you say, basically a fender bender is a African-American female plaintiff suing a Caucasian female defendant. And in the course of that trial, in cross-examining the plaintiff, the defense attorney asked questions were absolutely appropriate on cross-examination that go to bias and prejudice. So, for example, I think this is right. I might not be exactly correct on this, but I think one of the expert witnesses called by the plaintiff was her chiropractor to show the extent of her injuries. Well, you think it might be relevant for the jury to know that her chiropractor is also her employer. That kind of relationship would show some kind of bias or some kind of prejudice. There was also, I think, an argument made by the defense counsel in that case that it's a curious phenomenon that in the plaintiff's first visit to the doctor following the accident, apparently there was no mention of the accident or any kind of injury. And so in another example, I think during cross-examination, I think defense counsel in cross-examining the plaintiff noted that the plaintiff seemed much more cooperative with the questions posed by her attorney than by the defense attorney. That's a classic question, because it shows hostility, it shows bias and prejudice. And the court found, well, that just plays to the trope of the angry black woman, and that's fundamentally unfair, and it appeals to, at a minimum, or subconscious racial bias. And Judge Alito, this case after this matter was reversed, there was a direct appeal made to the U.S. Supreme Court, and the Supreme Court found that it was premature. But in his memorandum, at the point where it was found to be premature, so it's probably still going to be in front of the U.S. Supreme Court at some point in the future. As you mentioned, Judge Alito made some incredible remarks here. He described the decision by the Washington Supreme Court reversing the jury verdict in that civil case as a remarkable decision that appears to have no precedent in American law. The Supreme Court's decision, Washington Supreme Court's decision, raises serious and troubling issues of due process and equal protection. And it appears to mean that in any case between a white party and a black party, the attorney for the white party must either operate under special crippling rules or expect to face an evidentiary hearing at which racism will be presumed. And then finally, he noted, The decision below, far from combating racism, institutionalizes a variation of that odious practice. It's almost as if this is apartheid with a human face. In the effort to overcompensate for past wrongs and wrongdoing, the court has gone completely in the opposite direction. And it's well known, even in criminal cases, that not only is the defendant entitled to a fair trial, the state, the government, the people of the state are entitled to a fair trial as well. And I think that's maybe what's missing here.
The number of cases now, because the Washington Supreme Court has ruled of talking about particular words being used to creating bias and unconscious bias, that then, as you say, the lawyer representing the white defendant or plaintiff will have to choose words very carefully so that it doesn't all of a sudden you can't go, whoop, there's a word, that's a problem. Because at that point, you could call for the dismissal, or you could just throw the case out or start all over again.
Absolutely. And as I say, the standard, which is so subjective, the judge may consider any other information the judge deems to be relevant. What does that mean? I can give you an even more extreme example if you'd like.
Yeah.
If I don't know what you're doing for time. But in the choosing selection of a jury called voir dire, jury selection, there is a rule called General Rule GR 37, which disallows, as it should properly disallow, excusing jurors from jury duty by the lawyers, excusing jurors for improper motive, racial bias, sexual bias, ethnic bias, and things like that. That's absolutely appropriate. It denies a defendant the right to a fair trial, but it also denies a juror the right to serve on a jury. So that's absolutely appropriate. But what our Supreme Court done has now is, in a case called State versus Bell that's barely 4 weeks old, has now adopted a standard of review in cases where it's alleged that the prosecutor unfairly exercised a challenge to a juror, that racial bias, racial motive shall be presumed. And in that case, there was a jury selection was going on, and at the end of a jury selection, as jury selection goes on, both parties have the right to challenge a juror for cause. And that means for cause means you can't be fair. Your son's on trial, or you've been the victim of a similar type of crime. Therefore, you can't be fair in this case. And you can have an unlimited number of challenges for cause because you want a fair jury. But traditionally and historically, then both parties in criminal cases have a right to 6 peremptory challenges, not challenges for cause, but what are called peremptory challenges, in which historically you could challenge up to 6 jurors for any reason or no reason. You get this bad vibe that the jury doesn't think you're as clever and as funny as you think you are when you're selecting the jury, whatever's going on there. Well, and appropriately so, the U.S. Supreme Court in a case called Batson versus Kentucky said, wait a minute, it can't be for any reason or no reason. It can't be for any reason. And that if the reason is you're trying to strike persons of color from a jury, that's fundamentally unfair. And that's unfair to a defendant's right to a fair trial, in addition to the juror's right to serve on a jury. Well, what our court has done now, and if you take a look at State versus Bell, in that case, the defendant was charged with robbery, assault, rape, and burglary. And during the course of jury selection, the prosecutor said, I want to exercise my right to exercise a peremptory against a juror, who happened to be a juror of color. And the prosecutor said in his observation, the juror wasn't paying attention to the questions. And in fact, the juror admitted on the record that he was not paying attention or was losing track of a particular line of questioning. Defense counsel objected, said that violates General Rule 37. We must presume an improper, unlawful racial motivation here. The trial judge overruled the defense attorney's objection based on, in fact, the juror's admission he was not paying attention. The Supreme Court in its review said, well, just because the juror said it doesn't verify that it's actually a fact. And then also the judge made the observation, then in his own observation of the juror's demeanor, it was appropriate to dismiss the juror. And the Supreme Court said, well, that observation by the judge really isn't a finding of fact. It's based on his own subjective memory of the jury selection. In other words, the judge's corroboration, the judge is sitting there in the courtroom looking at the jurors who can observe the demeanor, the credibility of jurors. That's not relevant. Because what the Supreme Court says, we have to look at the entire record. And what do we have an entire record of? Well, not just that moment in time when that juror was being questioned and that challenge was being made, but of the entire jury selection process, because we've got a transcript. And John, you know as well as I do, transcripts tell you almost nothing about how a witness testifies. If you can't observe a witness to see what their demeanor is like, whether or not they're credible witnesses, whether they're consistent with other witnesses, transcripts, and I always suggest that 70% of all communication in a trial is probably nonverbal. and relying on a transcript when you've got a judge who is sitting in the courtroom observing that same juror and saying, that's not really relevant, just shows you how far the Supreme Court is saying, what we're going to do now is impose a standard that says if an objective observer could conclude that race was an improper motive in challenging a juror, then that's going to be a basis for a reversal. And here's the definition of objective observer. One who is, quote, this is the Supreme Court's definition, someone who is, quote, aware that implicit institutional unconscious biases, in addition to purposeful discrimination, has resulted in unfair exclusion of potential jurors in Washington state. In other words, it's critical race theory applied to jury selection. And the party's intent on challenging the juror has no relevance whatsoever. In other words, we're going to overcorrect for what are acknowledged injustices in the past by requiring current parties, current plaintiffs, current prosecutors to have to endure jurors who simply cannot be fair.
I get the idea of wanting to right wrongs, but you can't do that at the effect and the justice that needs to be served at that time. You're right. They've just decided they're going to swing the pendulum all the way back. Unfortunately, for the individual that is standing before the judge, either as a plaintiff or the defendant, now because of the new scope and filter of the Washington State Supreme Court, I don't know if justice will be served necessarily, especially if you look at the majority of crimes that are committed, they're interracial. It's a white guy against a white guy or a black guy against another black guy. So then where's race come into this? But again, the Washington State Supreme Court back in 2021 said they're going to do everything they can to make sure that, it's through the filter of race. And this is what we end up with. Wow.
You're right there. And the idea that's saying, well, the effect of the law, the enforcement of the law may fall disproportionately on persons of a particular racial or ethnic group says nothing about who the victims of those defendants are and how disproportionately those victims will be impacted in an extraordinarily negative way. We simply walk away from those cases because we're more concerned with the appearance of some type of fairness that's absolutely not rooted in any real world experience or in the law. And I'll give you one more example. In domestic violence cases. Domestic violence cases are phenomenally difficult to prosecute. Sometimes more difficult than homicide. I tried homicide cases for 25 years. DV cases come in front of the court, and in almost every DV case, a victim has recanted, has minimized. They won't show up for trial.
Yeah.
They won't sit for an interview to help them prepare. And what if you have the standard DV case in which that happens, and at trial the defense attorney says, Your Honor, the victim here would not cooperate. The prosecutor could not get the victim to a defense interview to help us prepare for trial. And the judge says, I think that's really unfair. I'm going to dismiss this case because of governmental misconduct because the prosecutor did not arrest the victim, put the victim in jail, and then have the victim available in jail for a defense interview. And the sad thing about this is 63% of DV victims in King County are persons of color. Who does that adversely impact? Persons of color.
Justice, I thought, was blind, but the Washington State Supreme Court wants them to peek through that blindfold every once in a while to see what color everybody is. Scott O'Toole, former Senior Deputy Prosecutor Attorney there at King County, thanks for spending some time with us. Appreciate it. Have a great weekend. Take care of that dog.